Let's start from three certainties. It's highly recommended that after this session, when you receive the slides and the recording, you have a look at this at our notes on three certainties that is provided here, the link to the notes. It's important that you know also this case, knight versus knight. Lord Langdale sets out three certainties required for the creation of a valid express trust. The said law must demonstrate the following: a clear intention to create a trust as opposed to creating something else. For example, you could have an intention to create a gift instead of a trust, which is often happens. And in a problem question, you have to make arguments as to why do you think it's an intention to create a trust as opposed to intention to create a gift, for example. The second principle, the trust property must be sufficiently segregated from the other property so that the trust fund is certain. It's called certainty of subject matter. And finally, the people who are to benefit from the trust have to be identified, certainty of objects. So we have to have, in order for us to have valid express trust in a problem question, we have to discuss whether or not there are the three certainties present: certainty of intention, certainty of subject matter, and certainty of objects. Example problem question. John died in 2019. His validly executed will contained the following provision: 15K for Joseph, in whom I have the fullest confidence that he will carry out this instruction to hold half of this fund on trust for my son, Lucas. So this is the kind of problem question you will probably get for three certainties. So it's important that you have a look at our model answers to see how to answer this kind of questions. You're prepared for this. And before reading the answers, good practice would be if you try to answer it yourself and then compare your answer to your model answer. Practicing to answer problem and essay question is the best way to prepare for your exam. Well, let's answer this question now. So three certainties have to be discussed. As we said, certainty of intention, certainty of subject matter, and certainty of objects must be there in order for the valid trust to be created. Now we have to discuss each of the requirements separately. For certainty of intention, a verbal expression of an intention to create a trust will be sufficient. The requisite level of obligation, the settlor must have intended to impose a legal obligation on the trustee as opposed to a mere moral obligation. So we have to have a look at the facts and define what is a moral obligation and whether or not the facts indicate that it's just a moral obligation or is it a trust. How do we do that? We have to have a look at the relevant cases. How did the court define in relevant cases what is merely a moral obligation and what is a trust as opposed to that? In this case, Lamb versus Eames, the statement "to be at her disposal in any way she may think best for the benefit of herself and her family" was held to be merely a moral obligation. This approach taken by the court in this case was that to impose a trust, the statement has to be read as a whole rather than any particular word. So applying this case to the facts that we have present here, we have to say to the examiner that we have to take the whole sentence we have here as a whole rather than word by word, and the whole sentence, the entire wording of the sentence, we have to define, we have to determine whether or not it's a mere obligation or intention to create a trust. It's somewhat similar to what the statement says here, so it could be argued that it's a mere it's a moral obligation rather than a trust. The use of trust that we see in the statement does not necessarily mean that a court will deem that to be a trust. That was stated in the case of Tito versus Waddle. Applying the above cases to this case, it can be argued that this is more of a moral obligation rather than a trust, because the discretion to put on the trustee to use the trust property as he considers right, similarly to Lamb versus Eames. Thus, there is no obligation on him to spend the money in a certain way. The statement is very similar to the one in Love versus Eames and demonstrates that the law's intention to create a moral obligation rather than a trust. Also, the fact that the word trust was used in the statement does not mean, it's not a conclusive proof that it will be an intention to create a trust. If you can find a case that suggests otherwise, you can use that. But from our experience, we found these two cases that was more suggesting that it was a moral obligation of trust. As we said, there is no right or wrong answer as long as you can support it from the cases and you can demonstrate on using the relevant case law that this is a moral obligation or this is a trust. From the case law that we have discussed here, it shows that it's a moral obligation more than it's a trust. Secondly, we have to discuss certainty of subject matter. Property which is intended to constitute the trust fund has to be segregated from all the other property for it to be sufficiently certain. And if there is no certainty of subject matter, the trust will fail. If either of the three certainties is absent, the trust will fail. Here, the application would be 15K segregated from the rest of the money. This is the question we are asking ourselves. And this is the main question point in the problem question. The court still, so if the 15K is segregated from the rest of the money, then it's most likely certainty of subject matter will be satisfied. But even if it's not segregated, this Hunter versus Moss principle could apply. In this case, it was decided that even if the shares of the company was not segregated from the rest of the shares, the trust was still valid because there was no difference from one share to another. So here we're talking about the money, and it's not actually that much of a difference to segregate the money from each, because it's just if it was about like bottles or about some kind of tangible object that is different from one another, that would be different. But for shares, for money, it's more likely that Hunter versus Moss principle will apply. So now, applying Hunter versus Moss, even if the money is not segregated, most likely the court may argue that there is certainty of subject matter. Thirdly, certainty of objects shall be discussed. For a non-charitable trust to be given effect at law, beneficiaries of the trust must be identifiable. Fixed trust, beneficiaries to interest must be specified. Fixed trusts enable the law to control money and assets for the benefit of the beneficiaries. Trustee of a fixed trust has little or no power at all to distribute the trust property or change the beneficiaries. So as we said, if the trust is charitable, then the certainty of object rule doesn't apply. But in this case, the trust is not charitable, so there has to be identifiable beneficiaries. How do we identify beneficiaries? There is a task from a regular banking case that is called complete list of beneficiaries, is or is not test, which means that any hypothetical beneficiary that comes into the room, we should be able to say whether or not he is or is not a beneficiary. That's the test. It reverses the previous rule that had required the trustees to be able to draw up a complete list of beneficiaries. So we're not required to draw up the complete list of beneficiaries, but is or is not test has to be applied. So any hypothetical beneficiary should be able to say whether or not he is or is not in the list of beneficiaries. Here is a fixed trust because the trustee can control the trust fund for the beneficiaries that lose sum. Is there complete list of beneficiary? Yes, the only beneficiary is the son of the said law. If we can easily identify that he is in the test of beneficiary. Conclusion: intention less likely to be satisfied because it seems more of a moral obligation according to the case law, but you could find a case probably that could suggest otherwise, but from the case law that we saw, it was more of a moral obligation rather than intention to create trust. Secondly, subject matter, if money is segregated, it should be satisfied, even if it's not segregated. Hunter versus Moss principle could apply and can still be satisfied. Third one, it's clear there is certainty of certainty of objects, because the only beneficiary is the son, he can be identified. Thus, the trust could fail on the grounds that the intention to create a trust is not clear, unless you can find a case that suggests otherwise. Charitable trusts is also a common topic that come up on equity law examinations. What are the main things you need to know about it? You should read the notes after this session that can be found on this link. But we can discuss the main requirements about charitable trust now. First thing you do about charitable trust problem question is you have a look at Section 3 of the Charities Act 2011. Section 3 has the list of charitable purposes, and you need to identify the most relevant charitable purpose that applies in your problem question. Once you identify that, then you can move to the next stage, which is public benefit test. Public benefit test basically means that every charity, every charitable trust has to have a public benefit. There are numerous cases on that, what qualifies as a public benefit and what does not. So you need to have a look at the main cases on our notes and make sure that you understand the main principles from the case law. Establishing a trust to pay for the school fees of the children in the case of Oppenheim versus Tobacco Securities was not a public benefit. Lord Siemens held that there could not be a public benefit if there was a connection between the people who established the charity and the people who were intended to benefit. This is a very important rule about charities, and most probably it will come up on the exam, so make sure that you memorize this rule about charities. There cannot be a connection between the set law and the people who are going to benefit from the charity. If there is a connection, that cannot be a charity. So, for example, if a father wants to set up a charitable trust for their children, for their education is a charitable purpose, but the charitable trust will fail on the second public benefit requirement, because there's no public benefit. He's just setting up a trust for his children. There is a connection. There cannot be a connection. So that's why the charitable trust can fail. There has to be public benefit test. So here we don't have certainty of objects element that we have for other trusts, but we have public benefit test that has to be satisfied. Therefore, the test for public benefit is from the trust if the trust constituted a sufficient section of the community. How do we answer a problem question on charitable trust? Firstly, we identify the right section from the list of purposes under Charities Act Section 3, and then we apply the public benefit test. How do we know if there is public benefit? Well, from the facts of the case, which should give you a hint if whether or not sufficient members of the society benefit from this trust. And also, you need to have a look at the relevant case law. The main, most important case on this topic is Oppenheim versus Tobacco Securities, but there are other cases you need to have a look. So make sure that you have a look at our notes on this topic. We also have a model answer on charitable trust, and you're highly recommended to have a look at the model answer and make sure that you answer the question first without reading the answer. Once you draft your own answer, then you compare it to our answer, and then that way you can know better where you went right, where you went wrong. If you need further help to answer your problem and essay questions to practice for your exams, you can book a tutoring session. It's highly recommended that before you go to your exam, you draft practice answers, and for drafting practice answers, you need someone to review it. And we do that as well in the tutoring session. Non-charitable trust is also one of the topics that often come on equity law examinations. We have very good notes on this that you can read on this link. This non-charitable trusts are express trusts, resulting trust, and constructive trust, or all trusts for ascertainable individuals. Non-charitable purpose trusts are sometimes referred to as private purpose trusts, and they are all void. Why are they void? Because of the lack of beneficiary. So the three certainties, it's basically about three certainties again. Three certainties have to be present for the trust to be valid. For the purpose trust, it's void because the third one, certainty of object, is not present. There is no beneficiary. It's necessary part of any trust that there is a beneficiary capable of enforcing the trustees' performance of their duties under the trust. This principle is known as beneficiary principle, and in the case of purpose trusts, it's void because there are no beneficiaries. Also, the perpetuity rule. This rule requires a future interest to be vested in a beneficiary within a certain time limit to ensure that the property is not tied up indefinitely in a long-term trust. The perpetuity period is 125 years. So if the trust is trying to set up a trust for more than 125 years, the perpetuity rule applies and it will be void. Important case law to read about non-charitable trusts is Ray Astor's case and Ray Shaw. Finally, fiduciary duties. Fiduciary duties, this is the kind of relationship where the trust between the parties arises. This is the relationship of trust and confidence. The example of this kind of relationship is company and director, principal and agent, trustee and beneficiary. These are all types of relationship that raises the trust and confidence. Summary of the legal positions for fiduciary duties. No profit should be made out of a fiduciary position. This is quite an inflexible rule of equity, that anyone who is in a fiduciary position, they cannot make a profit. So for example, if someone is a company director and some opportunity comes up for that to make a profit, and that could have well been used by the company itself, the director is not allowed to take the opportunity to make a profit, because people in fiduciary duties cannot profit from their position. Fiduciary must not place himself or herself where duty and interest conflict. So anyone in fiduciary relationship cannot have conflict of interest. Fiduciary must not act for the benefit of a third person. Directors must ensure that there is no direct or indirect conflict of interests, must not accept a benefit from a third party. If there is any possible conflict, they have to report. And if there is a specific provision, common law overrides equity. And these duties are also set out in the Companies Act. Important cases to read are set out here, and you will highly recommend that you have a look at all these cases after the session. And don't forget to practice. Example problem questions on this topic is available here. And please don't forget to have a look at past exam papers as well. Our model questions are great to practice, but the questions may be a little bit different for your specific university. That's why it's so important that you have a look at past exam papers and practice from it as much as possible. We can help you practice. So if you need help to practice from your past exam papers, you can book a tutoring session. To sum up, how do you prepare for your equity law exam? You analyze your exam requirements. You make sure you know exactly what you're required to do for your exam. And then you create a specific plan that focuses on you getting high grades. You don't need to study everything you covered on the course. You just need to focus on what's the most important to get a high grade. If you're unsure how to do that, we would highly recommend you to book a tutoring session with us. Thirdly, you practice. This is the most important. Just knowing the law is just half of the job, basically. The other half for you to get a high grade is to know how to apply your knowledge to the facts of the case and to the essay questions. So that's why it's so important that you practice, because legal writing skills, very good legal writing skills, does not come overnight. It comes over years of practice. That's why it's so important that you practice as much as you can on your own, as well as it's highly recommended that you get a tutoring session with us as well to practice with us. And finally, you make sure you follow your professor's guidelines. How do you do that? You make sure that you have a look at lecture slides. On lecture slides, professors often put some hints that they want the students to know during the exams, and they want the students to mention in their answers. Also, often professors give you some feedback on some practice essays. If they don't, you can ask them for it. You can draft some practice answers from past exam papers, send it to your professor and ask for some feedback. You may get it, you may not get it, but at least it's worth a try. So make sure that you try to get as much feedback as possible from the professor. Why? Because grading is subjective. The person who is grading your paper is best place to give you some advice on how to get a high grade. So make sure that you get as much guidelines as possible from your professor, and make sure you implement that in your legal writing skills. How can we help? On simple studying, we have top students and graduates who have already gotten high grades, who have been in your shoes and overcame all the difficulties and gotten high grades. They create simple study resources that focuses specifically on students getting high grades. So this way we provide you the right content you need to focus on, in addition to the lecture slides and materials that the professor gives you. Our materials is a perfect resource that you can use to know exactly how to get high grades. Our membership includes simple notes, simple sample answers, tutorial videos, quizzes, flashcards to practice for your exam, and some exam advices, as well as study groups that you can join for free. A lot of our materials are free, so it's great if you register and regularly study with our platform. Most importantly, 90% of our regular users, our regular premium subscribers, tell us that they get a first class. So make sure that you use our platform regularly in order to get a high grade. Law is not something you can study in a few days or a few weeks. Regular studying is the key to get a high grade. If the resources are not enough, we make sure that our resources are simplest to understand, and it communicates the right message in the least complicated way possible. But sometimes it's not enough, because law is the hardest degree to get a first class in. We understand that. That's why we have created an additional service, tutoring sessions, that you can book to get some additional help to prepare for your exams effectively. Make sure you book tutoring sessions to prepare for your exams. We have already helped thousands of students, and 90% of our regular premium users tell us they get a first class, as you can see on the reviews. We would love you to be our next student to get a high grade. Make sure that you join Simple Studying as soon as possible and start studying with us. Thank you very much for your time.